Understanding the law is the first step to fighting back. On March 4th, 2026, the United States Supreme Court issued a unanimous ruling that will directly affect how asylum cases are reviewed across the country. The case is called Arias-Orellana versus Bondi. Every one of the 9 justices agreed on the outcome. The opinion was written by Justice Ketanji Brown Jackson. Here is what the case was about. Douglas Humberto Arias-Orellana, his wife, Sarah Ileana Gomez Mejia, and their young child fled El Salvador in 2021. They came here after years of violence. A hitman working for a local drug lord had targeted the family. He shot 2 of Arias-Orellana's half-brothers. One of them was shot 6 times and left in a wheelchair. The sicario threatened to kill the entire family. Even after the family relocated to a different part of El Salvador, the hitman tracked them down and threatened to kill Arias-Orellana unless he paid a bribe. They entered the United States and were placed in removal proceedings. They applied for asylum. An immigration judge heard their case. That judge found Arias-Orellana credible, meaning the judge believed his testimony was truthful. But the judge still denied the asylum claim. The reason? The judge concluded that what the family experienced did not legally rise to the level of persecution under the Immigration and Nationality Act. The family appealed. The Board of Immigration Appeals upheld the denial. The family then appealed to the First Circuit Federal Court. That court also upheld the denial, applying what is called a substantial evidence standard, meaning the federal court deferred to the immigration judge's findings rather than conducting its own independent review. The family asked the Supreme Court to step in. At the center of this case was a technical but important legal question. When a federal appeals court reviews an asylum denial, how much authority does it have to second-guess the immigration judge? The family's lawyers argued that courts should be able to do their own independent analysis, what lawyers call de novo review, of whether the facts of a case meet the legal definition of persecution. They said the appeals court gave up too much power by simply deferring to the immigration judge. The Justice Department argued the opposite. It said the law requires federal courts to defer to immigration judges on these determinations, and that immigration judges, who hear the evidence directly, are in the best position to make these calls. The Supreme Court sided with the Justice Department, 9-0. Justice Jackson's opinion explained that Congress, when it wrote the Immigration and Nationality Act, intentionally gave significant deference to immigration judges on persecution determinations. She wrote that it would be, quote, anomalous indeed, to allow federal courts to conduct their own independent review of whether someone's experiences meet the persecution standard, when Congress had structured the law to give that authority to the executive branch. The court said federal appeals courts must use the substantial evidence standard. Under that standard, to overturn an immigration judge's decision, the evidence must be so compelling that no reasonable decision-maker could rule against the asylum seeker. That is a high bar. The ruling confirmed the standard that some circuits were already using, but it resolved a disagreement between different federal circuits that had been applying different rules. Now, every federal circuit must use the same standard, executive branch officials. Their decisions carry enormous weight, and this ruling makes that weight even heavier. When an immigration judge denies an asylum claim, the path to reversing that decision in federal court just became harder. Under the old landscape, before this ruling, some federal circuits gave asylum seekers more opportunity to challenge the immigration judge's persecution finding on appeal. A family whose case landed in one of those circuits had better odds of getting a second look. That variation is now gone. The substantial evidence standard applies everywhere. This does not mean asylum is impossible. The law still protects people who face persecution based on race, religion, nationality, membership in a particular social group, or political opinion. Immigration judges are still required to evaluate credibility and weigh evidence. The Board of Immigration Appeals is still required to review denials. Federal courts can still reverse decisions, but the evidence must be overwhelming. What this means practically is that the immigration judge's hearing, the first hearing, now matters more than ever. If you or someone you love is in removal proceedings and has an asylum claim, that initial hearing before the immigration judge is the most critical moment in the entire process. Evidence, witness testimony, country condition reports, and experienced legal representation at that stage are not optional. They are essential. This ruling also signals something broader. Courts are pulling back from immigration oversight. The space for federal judicial intervention is narrowing. That puts more pressure on the executive branch and on immigration judges themselves to get these decisions right the first time. The asylum backlog in the United States currently stands at roughly 2.4 million pending cases in immigration courts, representing about 63% of the total immigration court backlog. The Supreme Court's decision will likely speed up the review process for denied claims, since federal courts will now do less independent fact-finding on appeal. For families waiting years in that backlog, a faster resolution sounds promising. But faster is not the same as fairer. Advocates for immigrant communities have raised concerns about whether immigration judges, who operate under enormous case volume and institutional pressure, are well positioned to serve as the final, effectively unreviewable decision-makers on life-altering claims. The family in this case, it bears repeating, was believed. The immigration judge found the father credible. A hitman had shot his family members. The family had relocated and still been found. They still lost. That outcome, believed but denied, is now harder to challenge in federal court. Immigration rights advocates will be watching how this ruling plays out across the country. Some legal scholars note that while the case resolves the standard of review question, federal courts retain their authority to review legal errors, meaning if an immigration judge misapplied the law, that is still reviewable. The ruling narrows factual review, not legal review entirely. What happens next? The ruling is final and binding on all federal circuits. No further appeal is available for this family. Congress could change the asylum statute, but that is unlikely in the current political environment. The Supreme Court is also set to hear arguments on birthright citizenship and other immigration-related cases this term, meaning the legal landscape continues to shift. If you are in removal proceedings, here is what you need to know right now. Document everything. Keep records of every threat, every incident, every piece of evidence that supports your fear of return. Photographs, police reports, hospital records, affidavits from witnesses, all of it matters, and it matters most at the immigration judge stage. Understand that your hearing before the immigration judge is your most important moment. After that decision, the path narrows significantly. Get legal representation if you possibly can, and get it early. If your asylum claim was denied and you are still within the appeal window, consult with an immigration attorney about whether the Board of Immigration Appeals or a federal circuit court still offers you options. This ruling does not eliminate those options. It raises the bar for success. Country condition evidence matters. Reports from the State Department, human rights organizations, and news sources documenting conditions in your home country can support your claim. Make sure your attorney presents that evidence during your hearing. Stay informed and know your rights. Record today, protect tomorrow.